Hi, my name is Cullen, and I'm a personal injury attorney in Winter Park, Florida. We talk to a lot of people who have been involved in trip and fall or slip and fall accidents, and one of the first questions that we ask everybody that talks to us about these types of cases is, do you have any pictures? Did you get any pictures or video of what caused you to fall? And a lot of people seem kind of annoyed by this answer, and usually it's because when they tripped and fell or slipped and fell, they were embarrassed or they were injured or they just didn't think about it or didn't have the wherewithal to reach into their pocket, pull out their phone, and take a picture. But I'm here to tell you that pictures are some of the most critical things that we ever have when we're trying to prove a slip and fall or trip and fall or premises liability case. A lot of people have the mistaken impression that if they fall inside of a business or on a piece of property or somebody else's property, that person is automatically responsible for paying their medical expenses or their damages. And that's just not true. In the state of Florida, the law is that we can only make a property owner or business owner pay damages to our clients if we can prove that the property owner or business owner was somehow negligent or was acted unreasonably in some sort of way. Part of proving negligence is proving that a condition existed on the property that was dangerous, that either the property owner knew about and didn't fix or alleviate, or that the property owner should have known about. So it existed there and was it existed in a way that the property owner, if they were acting reasonably and maintaining their property reasonably, would have seen it and been able to fix or remove it. As a practical matter, and sort of as a legal one as well, it's virtually impossible to prove that a dangerous condition existed on a piece of property without being able to show the fact finder or the jury or the judge in a case what the condition looked like when the plaintiff encountered it or when it injured the plaintiff. That's why it's so critically important that we have pictures or an accurate way to describe what the dangerous condition looked like at the time of the injury. And the classic example of a situation like this is someone who's in a grocery store and slips on some sort of puddle of liquid that's on the floor. A store has a duty to use reasonable care to keep their store safe, and that includes doing sweeps through the aisles of the stores or having somebody go through the store and look around and make sure that there's nothing on the floor that might be dangerous to people. And that would include spills or leaky machinery or refrigerators in the store and things like that. Now, a store only has a duty to clean up the things that it either knows about or should know about. It's nearly impossible for us to ever prove that a property owner knew that a puddle existed, so normally we're trying to prove that they should have known about it. And one of the ways that we can prove that they should have known about it is by proving how long it was there. And sometimes we can get an employee or somebody, a bystander, to say, hey, I saw that puddle there, and then 15 minutes later somebody slipped in it. But usually we prove that by showing a photograph of whatever it was that caused our client to fall. In the grocery store example, it would be a puddle that would have shopping cart tracks, multiple shopping cart tracks strewn through it. Or maybe there are a ton of shoe prints or foot traffic that walk through this wet area, and you can see the footprints throughout the aisle. You know, things like that would help us prove that the danger existed for a long enough time that somebody in the store should have seen it and should have cleaned it up. That's why photographs are so powerful in these cases, and that's why it's so critical for us to get them if they exist. And one of the other ways we do that is by asking stores for their surveillance video or surveillance footage, because sometimes that will reveal how long a danger existed on the property. But surprise, surprise, a lot of times when we ask for this information, the store says either that their cameras didn't work or that they've already taped over it, or for some other reason they can't come up with the video that shows our client's fall. And there are probably many, many other examples of why photographs are important, but this is just one, and this should give you a feel for why we always ask this question. So if you have any questions about a slip and fall case or a trip and fall case or the importance of photographs to proving those cases, reach out to us. We love to answer questions. All you have to do is call us at 407-254-4901, or you can text us at 407-644-4444, or you can even reach us through the Facebook Messenger app.